Hello, everyone. This is AJ Weisler, and I'm a partner in Husch Blackwell's Labor and Employment Group, and I am excited to welcome you on behalf of Husch Blackwell to this, the fifth in our series of 6 virtual labor and employment seminars this fall. If you've had the opportunity to join us in the past, you may have seen me when I hosted the national program as well, and hopefully you've had a chance to join some of the other regional programs that have taken place over the last 4 and 5 weeks. And our final program will be next week when our colleagues from Wisconsin provide their update on the happenings up there. And for those of you who have joined past virtual webinars when I've hosted, I wanted to notice, and you may have already noticed, that I am presenting from my home this time instead of using the relative peace and quiet of the Husch Blackwell office. So we'll keep our fingers crossed that my home internet works out, and of course I'll ask for your understanding that I am sharing the space today with an extremely loud dog that has strong opinions about delivery people, 1 out of 2 children learning downstairs, and 1 out of 1 spouses working on the couch in the other room. But I am excited that you're able to join us today. I think that my colleagues have put together a very entertaining and very informative program. And before we begin, as we always do at the beginning of these virtual webinars, we'd like to cover a few housekeeping items, and then we will send you to our first set. On your screen, there are multiple boxes and icons for your use during the program today. I would like to take a minute to highlight a few of the key items for you. First, if you're having any technical difficulty, please refer to the audience technical tips on your screen or click on the help icon at the bottom of the screen. It has a question mark and provides information regarding common technical issues. If you happen to be viewing the program from a mobile device, turn your phone landscape for optimal viewing, and when the screen is landscape, you can click on the box in the lower right corner to change your layout. If you have any questions during the program, please submit them via the question box. We will try to answer all questions during the program today, but if a fuller answer is needed or if we run out of time, it will be answered later by email. We truly appreciate the audience participation and encourage you to submit questions. A copy of the presentation, speaker biographies, and links to connect with us on social media are available in the resource folder. This program has been approved for HR and legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan our future programs to ensure that they are applicable to your business needs. Joining me today are Husch Blackwell attorneys from our St. Louis and Chicago offices, and they have put together 3 sections of content, each about 25 to 35 minutes long. And we will have a short break between each section in case you need to step away for a few minutes. But please be aware that we do have some fun planned for the breaks, so you may not want to stray too far from your screens. To kick off our program, we will share some legal updates. Next, we will be discussing some practical lessons about how to defend charges of discrimination after some recent changes to the Missouri and Illinois anti-discrimination laws. And finally, we will be talking about how to leverage those virtual capabilities, some of which we're all demonstrating to you today, when you go out and conduct employee meetings, investigations, and participate in litigation, even after your workers have returned to the office. First up, we're going to send it to Carrie Claiborne, Danielle Reed, Bob Tomaso, and Sarah Quinn to provide the legal update. Take it away, Carrie and Danielle.
Thanks, AJ. I'm Carrie Claiborne out of our St. Louis office, and I'm here to do the legal update. I'm here now with my colleague, Danielle Reed, and then later we'll be joined by Bob Tomaso and Sarah Quinn. We're going to start with a federal update, and then we'll move into Missouri and give you some updates on what's going on in Illinois. So first, for our federal update, Danielle and I will talk to you about the Pregnant Workers Fairness Act, the recent executive order issued on September 22nd, a DOL proposed rule on independent contractors, and finally, a brief update on OSHA reporting guidelines. So I'll turn it to Danielle for our first topic, Pregnant Workers Fairness Act.
Thanks, Carrie. On September 17th, 2020, the U.S. House of Representatives passed a bill known as the Pregnant Workers Fairness Act. It's now pending in the Senate, but due to the current makeup of the Senate, COVID-related issues, and other priority items, we think it's unlikely that it'll pass during this session. But we wanted to go ahead and let employers know about it and kind of explain what it is generally and what it would require. If it passes, it would apply to private sector employers with more than 15 employees, as well as all public sector employers. In general, it requires reasonable accommodations for pregnancy, childbirth, and related medical conditions unless the accommodation would impose an undue hardship on the employer. The Pregnant Workers Fairness Act would use the same interactive framework and definition of undue hardship as the ADA. The Pregnant Workers Fairness Act in general prohibits denying employment opportunities based on the need for reasonable accommodation, requiring employees or applicants to accept unnecessary accommodations, requiring employees to take leave if another reasonable accommodation could be provided, and of course retaliating against individuals who request or use an accommodation or engage in activity protected under the Pregnant Workers Fairness Act. Again, we think it's unlikely that it'll pass during this session, but if it were to pass, employers should consider reviewing and revising their policies on reasonable accommodations and training managers and supervisors on procedures for responding to accommodation requests from pregnant employees. We'll also note that Illinois employers are probably already in compliance with the Pregnant Workers Fairness Act because the requirements are very, very similar to the Illinois pregnancy accommodation law that was passed a few years ago. And now we're going to go back to Carrie to hear about President Trump's recent executive order on diversity training.
Thanks, Danielle. So many of you have probably heard about this order or something about it. It's titled Combating Race and Sex Stereotyping. The executive order was issued on September 22nd, and it will go into effect November 21st. So it'll apply to any federal contracts going forward after the 21st or entered into after the 21st. What the order does is generally, I'll give some more specifics on the next slide, but it bars federal contractors from including what are being called divisive concepts in workplace training. It seems to get at training related primarily to diversity and inclusion. And it applies to, like I mentioned, federal contractors. It also applies to employers who receive federal grants. And it will flow down to any subcontractors or suppliers as well. So it's going to be enforced by the Office of Federal Contract Compliance Programs, also known as the OFCCP. And although it may seem unlikely that you do violate the order, you'll want to be sure because the consequences of any violation could be very huge, even resulting in cancellation, termination, or suspension of a contract, and going as far as suspension or debarment from future contracts. So what is in the order? Well, here you'll see a list of specifics. I won't go through them all, but you can see the primary focus of these specifics that are listed in the order is to eliminate assigning blame, stereotyping, also the term scapegoating is used. So the point is, yes, employers should still be doing diversity training, diversity and inclusion, but you're also going to have to navigate making sure you don't go so far as to blame and assign blame based on inherent characteristics like sex or race. So this may, again, seem tricky for folks, for federal contractors who are still required to comply with equal opportunity and affirmative action requirements, but now making sure that you're avoiding violation of this order and any kind of endorsement of divisive concepts. What can you still do? It's clear what you can't do, but I want to point out a few things that you certainly can still do, which is Secretary of Labor Scalia touched on this a bit. Yes, you should still be doing diversity and non-discrimination training. It's not meant to stop those things. You can actually even still talk about divisive concepts or things that could potentially seem offensive, assigning blame in a historical context, so long as you're doing it in an objective or even academic way rather than promoting or endorsing this type of blaming. So what should you be doing next aside from continuing your training? You will want to add language into your future contracts about prohibiting the divisive concepts. This is laid out in the order. You'll want to include the written prohibition in future contracts. You need to provide notice to employees about this prohibition, as well as notice to any kind of union representative. And then you're going to want to review your training materials and just ensure that you are not treading into this area where you are promoting or endorsing the divisive concepts. So back to you, Danielle.
Thanks, Carrie. The Department of Labor published a proposed rule on September 25th, 2020 concerning independent contractor status under the Fair Labor Standards Act. The proposed rule adopts the economic reality test for determining whether a worker qualifies as an independent contractor under the Fair Labor Standards Act. The analysis would shift from the current framework, which is consideration of 7 factors, none of which are determinative and all are given equal weight, to a framework that would focus on consideration of 2 core factors: the nature and degree of the individual's control over the work and the individual's opportunity for profit or loss. If those are conflicting or point in different directions, the new rule would allow for consideration of 3 additional guideposts. The proposed rule should simplify the framework for classifying workers as independent contractors, but comments are due by October 26, 2020 if you have any input on this proposed rule. And now back to Carrie to tell us about recent guidance issued by OSHA.
So the recent update, it comes in OSHA's FAQs. You can find them on the OSHA website. September 30th, these came out. And the intent is to help clarify what reporting obligations you have related to any inpatient hospitalizations or deaths resulting from exposure to COVID-19 in the workplace. That's been a confusing topic during the pandemic, and so OSHA did give some new guidance that we think will be helpful if you end up in this very unfortunate situation. It helps to figure out the deadlines and what indeed constitutes an incident. So now that's it for our update, and we're going to do a quick technical switch, and Danielle will be back with Bob to talk about Missouri.
Thank you, Carrie, for that introduction. For those of you who don't know me, I'm Bob Tomaso. I'm not only an employment lawyer here at Husch Blackwell, but I'm also the office managing partner of our St. Louis office. Let us start the Missouri update by introducing you to my colleague, a great young lawyer, Danielle Reed. Danielle?
Thanks, Bob. On September 29, 2020, the Missouri Supreme Court issued an order amending Rule 57.03, which governs depositions upon oral examination. The rule in its current form allows a party to attend a deposition by telephone, but it does not authorize fully remote depositions because the witness must be in the presence of the notary or person administering the oath. The amendment to 5703 expressly authorizes remote depositions because it allows all parties to attend remotely by stipulation or court order, which is similar to Rule 30b-4 of the federal rules. The new 5703 goes further than the federal rules because it authorizes attorneys to attend by remote means, absent stipulation of the parties or court order. However, witnesses will still be required to attend in person unless they can agree with the parties or they have a court order allowing them to attend remotely. And now Bob will tell us about the recent amendments impacting punitive damages.
So we've got some good news in Missouri on punitive damages. They're supposed to be harder for an employee to obtain. I will say, getting back though to what Danielle was telling you about remote depositions, we've had a heck of a time. I don't want to take the plaintiff's deposition in the big case remotely. Kate Copen and I had to go down to Rolla to take a deposition live of a plaintiff in a big case recently. And it's a little tough to take a deposition these days in the age of COVID. But that change is helpful for most depositions. Okay, punitive damages. Look, there's really only one thing that is guaranteed to get you and me, you as in-house employment counsel or HR person, and me as outside employment counsel fired. And that's when a company is hit with punitive damages. Supposed to be rare in Missouri. There's been a change that should help. Because on August 28th, the effective date for this new law, and I point out the effective date, which I don't normally do because this law applies going forward prospectively to actions filed on or after August 28th. If a lawsuit you're currently defending was filed before August 28th, then this new change in punitive damages doesn't apply. What the new law does is it raises the standard for punitive damages in civil actions. I will tell you, at first glance, the change in the language really seems to be a matter of semantics. Basically, now a plaintiff must prove by clear and convincing evidence that the defendant intentionally harmed the plaintiff without just cause or acted with a deliberate and flagrant disregard for the safety of others. The old standard, sounds similar to me really, was a showing of complete indifference to or conscious disregard for the safety of others. Again, I think that's a matter of semantics. The real issue comes in the procedure by which punitive damages may be awarded. And the way we get there is we don't get there unless a judge decides that the evidence that he has seen so far, he or she has seen so far, could justify an award of punitive damages. So it does require more than nominal damages. 510.261.2 prohibits the award of punitive damages if the trier of fact awards merely nominal damages, actual damages. That is, if the underlying case, let's say somebody was never discharged, never suspended. So the plaintiff didn't have much in the way of actual damages. In that case, punitive damages should not be awarded. There are some exceptions for privacy rights, property rights, constitutional claims, probably don't apply to most employment cases. And also punitive damages can't be awarded based on harm to non-parties. Now, we'll see in this slide, it does raise the pleading standard. It's a little technical, but I think it's worth knowing for you all, and requires evidence of intentional wrongdoing. Those 3 bullet points in the middle are pretty important. The party may not seek punitive damages in the initial pleading, that is in the lawsuit itself. What a party has to do is 120 days prior to the trial date or prior to the final pretrial conference is to ask the court for leave to add a claim for punitive damages. And there's going to be a big fight. The good news is at that stage, a judge could instruct, nope, you haven't shown me enough to justify punitive damages. The plaintiff must present evidence, not just theory, argument, but evidence establishing a reasonable basis for those punitive damages. Another way this is going to be important is that in mediation or settling, and we often do settle civil cases, this probably gives the employer more leverage to say, well, we're not going to pay what you want because the punitive damage standard has changed, and we feel pretty confident you're not even going to get an instruction. The judge isn't even going to allow the jury to consider punitive damages. And then the other issue, finally, is that punitive damages against an employer for the acts of its employees are somewhat limited. I mean, the principal or managerial agent must have authorized the doing in the manner of the act, or the agent must have been unfit, that never should have been hired, or we shouldn't have retained him or her, or the agent could have been employed in a managerial capacity, or acting outside the scope of employment. And finally, the principal or managerial agent of the principal could have ratified or approved the act of another person. Look, all that can happen. Again, I think the important thing is there's a better chance that a judge might say, nope, not going to instruct on punitives, and going to be awfully hard for the plaintiff to get punitives, which might save you and me our jobs. Now back to Danielle.
Thanks, Bob. Next, we're going to talk about the Crown Act. On October 1st, 2020, the Kansas City City Council passed the Crown Act, which will go into effect on November 1st, 2020, and it prohibits discrimination based on natural hairstyles and hair textures that are typically associated with race. It does so by expanding the definition of race to include the traits historically associated with race, including but not limited to hair texture and protective hairstyles, including braids, locks, twists, afros. The definition, by saying including but not limited to, leaves open the possibility that other traits historically associated with race could constitute forms of race discrimination. So for Kansas City employers, be sure to review and revise your policies to ensure compliance with the Crown Act before it goes into effect next month. And that does it for the Missouri legal update portion. Thank you, Bob, for joining me. And now we'll turn to our colleagues, Carrie Claiborne and Sarah Quinn, to tell us about Illinois updates.
Thank you, Danielle and Bob. And I'm back now with my colleague in Chicago, Sarah Quinn, and we are going to give you an Illinois update. So we're going to talk about mandatory sexual harassment training under the Illinois Workplace Transparency Act. We'll give you an update on the Biometric Information Privacy Act, also known as BIPA, and then an update on Chicago's Fair Workweek Ordinance. So first, Sarah.
Thanks, Carrie. I will be talking to you about the mandatory sexual harassment training requirement for all employers with Illinois employees. And this comes to you under Illinois' new Workplace Transparency Act that went into effect this year. This act requires that every employer with one or more employees in Illinois must provide training by December 31st of this year and every year after that. This training can be found on the Illinois Department of Human Rights website, where they have provided a model training program that is available to employers and to the public free of cost. However, employers are free to create their own training as long as it complies with the act. The act requires an explanation of sexual harassment consistent with the Illinois Human Rights Act, examples of conduct that constitute unlawful sexual harassment, a summary of relevant federal and state statutory provisions concerning sexual harassment, and a summary of responsibilities of employers in the prevention, investigation, and corrective measures following sexual harassment. Now, employers are free to give the training themselves using the Illinois Department of Human Rights model training, or have a third-party vendor or organization provide the training as long as it complies with the act. Employers should review any third-party training to ensure that it meets or exceeds those minimum standards. And for a shameless plug, Husch Blackwell has, of course, developed a model training compliant with this act. And please let us know if you'd like to discuss the different options available for customizing and delivering this training to your business. It's important to note that all employers must train their employees on an annual basis, and that includes part-time, full-time, and even interns. Employers should make sure to provide the training to new staff as soon as possible after hire, and the training must be accessible. So consider your employees with disabilities or those that native language is different than English. Finally, there is an additional requirement for restaurants and bars. So if you fall into one of those categories, there's additional information that needs to be provided to your employees. Turning back to you, Carrie.
Okay, so the Biometric Information Privacy Act, also known as BIPA, is an Illinois act that we have talked about a little bit, so I'll give you a brief refresher. It's a pretty unique statute in Illinois, and it is meant to regulate the collection by a company, either from customers or, for our purposes, employees, of biometric information, meaning most commonly things like fingerprint scans, which some employers use for time clocks or access to facilities. It can also be retina and facial geometry scans. Under the Act, there are penalties for, quote, a violation, either a negligent violation or a willful violation, $1,000 or $5,000 per violation, or actual damages if those are greater. What BIPA does not do, though, is define what a violation is and when it accrues. So the lack of guidance in that area, with not having a definition, over the last couple years, parties have been arguing about when it accrues, either at the beginning of this process, so when they start collecting information, or on the other hand, plaintiffs' attorneys have generally argued it's for each scan would be considered a violation. So now, for the first time this summer, a federal court has weighed in on this. This is in the case of Cothron versus White Castle that came out this summer. And basically the court held that each individual scan of an employee's fingerprint would be considered a violation of BIPA. So in this case, the plaintiff was a manager for White Castle, and for several years they had been doing fingerprint scans without the proper written consent. So she probably scanned her finger multiple times each day, like many employees did, before actually doing the proper release. Once they did get the proper release, then she sued, and it was a class action. And the court looked at it in the context of a motion to dismiss. And looking at the act, this court's view was that it's not ambiguous. And indeed, each individual scan, which again, in this case, was multiple times per day by multiple employees over several years, could be considered a violation of the act. So the bottom line is this could lead to very large exposure for employers who use any kind of biometric information. And it's something more than ever you want to be sure you are complying with the act. Again, just as a note, it was a federal court interpreting Illinois law, so it could certainly change, but this is a big development for BIPA. And back to you, Sarah.
Thanks, Carrie. And finally, for our Illinois update, I'm going to talk to you about the Chicago Fair Workweek Ordinance. This ordinance went into effect recently, July 1 of 2020, and it guarantees that employees in certain industries be provided with predictable work schedules so they can reasonably plan their income and their lives. It gives employees a series of rights to secure that predictability. But first, let's talk about who is a covered employer under this act. In order to be a covered employer, a company must employ 100 or more employees among all of its locations, whether in Chicago or outside. And then number's 250 if you're a nonprofit corporation. Second, among its global count of employees, it must have 50 covered employees who spend the majority of their time working in Chicago and earning less than $50,000 in salary or $26 per hour, and is primarily engaged in a covered industry, those industries being building services, healthcare, hotels, manufacturing, restaurants, retail, and warehouse services. Finally, if you are a franchise restaurant, it must have over 30 locations globally, at least 250 employees, and for purposes of being an employer under this act, shall have at least 4 locations in Chicago. So what are these rights? Well, a covered employee has the right to decline unscheduled time, as long as that time has been changed within 10 days of the work schedule. Also, that employee has a right to predictable pay, and if the shifts either added time or decreased time or the date is changed of their shift, they're entitled to 1 hour of additional pay. Employees are also entitled to pay for canceled hours, and any cancellation of hours within 24 hours notice entitles them to 50% of the pay they would have got if they worked that shift. Next, the employee is entitled to rest, which means they're entitled to decline any shift within 10 hours of the end of their last shift, but if they accept that shift, they get 1.25 times their base rate of pay. Of course, they're also entitled to an estimated work schedule, which is a good faith schedule on behalf of the employer of the days of the week and the hours they're expected to work. And of course, if their rights are violated, they have the right to submit a complaint. Most importantly, though, many employers have asked, well, what do I do? We're in the middle of a pandemic. Employers must follow these onerous requirements unless the pandemic has caused a change in the goods or services they offer, in their operating hours, or their operating plans. And they're only entitled an exception to these rules in the week of the change and the week following the change. So it's really important that employers get in line with these somewhat onerous requirements. That concludes our Illinois update, so I turn it back to you, AJ.
Thank you very much, Sarah, and thank you to the rest of the team on a great legal update today. This brings us to our first poll question, which today is, does your organization use biometric screening, fingerprints, retina scans, facial recognition for any of your employees in Illinois? And of course, you have options of yes or no, or perhaps this question is not applicable to your organization simply because you do not have employees in Illinois. Thank you all for your responses. And speaking of facial recognition, there's probably no better evidence about how lucky my family and I have been during this pandemic than the fact that maybe the greatest hardship I experience on a daily basis is that my phone's facial recognition doesn't know who I am when I'm wearing a mask. And I'm sure that Apple and other companies are working on that as we speak. So now it's time for the first of our 2 scheduled breaks for today. This first break will last about 10 minutes, and the second break will take place after the next round of substantive presentations, and it will last about 10 or 15 minutes as well. So feel free to step away if you would like, but you are also welcome to stick around because we do have a couple of presentations that we're going to show you during each of the 2 breaks. And for those of you who have joined us live in St. Louis in the past, you know that at our live seminars, we like to put together some content for some of the breaks that's intended to be, informative, but also entertaining and maybe just hopefully a little bit funny. And it occurred to me that with this wider audience in a virtual format, there are a lot of people who probably haven't joined us live in the past, or maybe only sometimes in the past. And so I thought this is an opportunity to dig deep into the vault, to dust off some old footage of some of the presentations that we've put together for you and for our audiences in the past. And it allows you to see some of the attorneys who are going to be presenting today, some of the attorneys who you've seen present before, in a different light. It shows that not only are they excellent legal scholars and knowledgeable presenters, but at least some of them are also a little bit funny. And so what we're going to do is go back in time and work our way through some of the greatest hits of Husch Blackwell St. Louis's Labor and Employment Seminar Humors Past. And I hope you'll enjoy that trip with me. For our first bit of humor from seminars past, let me take you back to September of 2013, when we presented to our audience some information that we had found on the internet about a disturbing trend with employees providing videos about how to take advantage of their employers and the employment laws that protected them. And we really viewed it as a public service to make our clients and our audience aware of those issues. And we showed several examples, and we'll show one of them today, of a particularly loathsome person we found who had made a number of these videos. Hello, welcome back to my blog. This is post number 515, and today I'm going to talk about probably one of the most important things that you need if you're going to get away with anything at work, and that is a scapegoat. I think the easiest way to really explain it is to start with an example. So take a look at a little footage of what happened around here today.
Hey, AJ.
Oh, hey, Sonny, what's up?
Hey, do you know what happened to that ice cream that was in the freezer for Jeannie's birthday?
Oh, the ice cream for Jeannie's birthday. You know what? I saw Brittany going into the kitchen earlier. I didn't see her eating the ice cream, but I wouldn't really be surprised.
Brittany, yeah.
Yeah, and I don't think I'd say anything to her. She's been having kind of a tough time at home, with her husband and everything. Like yesterday, she got real embarrassed when she was accused of eating Becky's lunch. She wouldn't even admit that she had done it. So let's maybe let this one go.
All right.
All right, thanks.
So basically, over the last 2.5 years, I've blamed everything that I've done on Brittany. No one likes Brittany, so everybody immediately jumps to assuming, honestly, sometimes I don't have to blame things on her anymore. I mean, they used to like her, but I've blamed enough stuff on her where they're really starting to question her work ethic and, well, frankly, her morals. I blame her when the copier's out of paper. I blame her if there's a paper jam. I blame her when I start a small fire that burns down a bit of the building. Anything that happens, you get out in front of it, you make sure people know it's probably Brittany. Before Brittany, actually, it was Kate. Kate was an excellent scapegoat. Problem is, blamed a few too many things on her, and the company actually, they let her go, which is, I kind of feel bad about that. She's got kids, a few cats, a couple dogs, but I'm sure she's doing fine. She was really good at her job. She'd probably still be here if it weren't for the fact that she had to be my scapegoat, but somebody has to. And I highly recommend you find one around work. Identify that person who maybe is a little different, and maybe someone, crosses you on the first day. Brittany, for example, brought me chocolates to welcome me to the company, but they were dark chocolates, and that's disgusting. So she deserves it. But yeah, episode 515. Get yourself a scapegoat. Wow. I mean, that is just obviously just some terrible, terrible advice. And yet I just can't help myself kind of liking and trusting that person. And for our next blast from the past, we go back to the fall of 2014. A lot of times when we do our fall seminars in the St. Louis area in particular, not only are we talking about the law and legal updates, but our attention and our audience's attention is often turned towards what's happening in the baseball scene. And that's, of course, because we root for the home team, and that's the St. Louis Cardinals, and they tend to play pretty deep into the fall. And we also realize that as St. Louis attorneys, it's invigorating to be around such a winning culture, and we've really taken that to heart. For example, something that we think baseball players do maybe better than anyone is celebrate when they do something great. And so we have found as attorneys to look for opportunities to celebrate our own successes, our clients' successes, our colleagues' successes, but that can be kind of difficult. And that's because even though we are phenomenally talented athletes, in addition to being lawyers, professionally we don't get to hit very many game-winning home runs in front of 45,000 people screaming for us. And actually, this is something that the attorneys in the audience certainly know, but maybe others aren't aware of. As lawyers, when we win, we find out about it usually through an email that comes to our phone with an order from a court saying, hey, congratulations, that case you've been litigating for the last 10 years, you just won it. And so it can be hard to, in that moment, celebrate it the way that it should be celebrated. But we've actually come up with a way to make that happen.
All right, so we're going to have to get that on file sometime before the first of the year. Hold on, wait a second. Wait a second. We won! We won! Oh, yeah! It's a lot of struggle.
Despite the fact that that was filmed 6 years ago, Joe actually still has a handful of the bruises that he experienced at the hands of his colleagues that day. And another thing that lawyers and baseball players share in common is an understanding of the importance of confidentiality. In baseball, when they're having their conversations on the mound, they usually go to great lengths to ensure that nobody can hear them or even read their lips by talking into their gloves. And, we obviously take similar precautions when we're protecting the confidential information of our clients. But even around the office and internally, we have found that this is a reasonable tactic for keeping information away from people that you don't want to have it.
Let me look here. Hey, Sonny, what's on tap for tonight?
We're going to the game, right?
Yeah, we're leaving early, I thought.
Okay, cool.
Hey, what are you guys doing tonight?
Working late.
Oh, really?
Yeah.
That video, along with several of the others that we're going to watch today, actually involve footage of former colleagues, Husch Blackwell attorneys who've gone on to work in different locations now, and many of whom are actually in the audience today. And if any of you are in the audience and you would prefer that your image and likeness not be used in any additional videos, just please let me know in the next few seconds, and if not, I will take your silence to be consent. A final tradition that we had adopted back in the fall of 2014 was starting the day like a baseball game with a beautiful rendition of the national anthem. It remains incredible to me that I ever let an audience hear me sing, that was ever something I thought was going to be a good idea. And, obviously I was singing intentionally badly. If I wanted to, I can and do sing beautifully all of the time. But not only was it a bad choice 6 years ago, it's a totally impossible choice that I decided to do it again to a virtual audience in 2020. And finally, we're going to end this first session with some advanced interviewing techniques that we demonstrated to our audience in the May of 2015. We find that not only do we want to give you legal advice, but this is an opportunity for us to give you practical, real-world advice, because you're employees and you interview. And so we actually went into the archives and we found footage of our attorneys responding to some difficult questions. And I pulled one of those questions so you can get a sense of how they handled it, and maybe it will inform you the next time you interview. For your consideration today, we're going to show you how 3 of our attorneys, starting with Sunny Nolan, answered the always difficult question, can you explain this 1-year gap in your employment history?
Great question. Yes.
Obviously, Sunny is demonstrating exactly how to be both a good interviewee and a good deponent. Only give them the answers to the questions they ask.
Great question. You want the truth? Well, you can't handle the truth. Jack Nicholson, A Few Good Men, eh?
To my knowledge, that was the one and only time that Kate Copen did that particular impression, and she did it so perfectly and so purely that it was never to be done again.
That's a good question. Actually, I normally take off for a year, about every 4 years, and go to an orphanage in Africa. No, just kidding. Actually, what happened is that I got hooked on Xbox, and so the year kind of disappeared.
Not a lot that can be said in response to that. And that takes us to the end of our first humor session and our trip down memory road to humor's past. And next up, we're going to send you to Kate Copen, Damia Park, and Randy Thompson from our St. Louis office, who will be joined by Ann Mayette from Chicago to present some practical lessons that they can provide for defending against charges of discrimination in the wake of the recent amendments to the Missouri and the Illinois anti-discrimination statutes. And to kick it off, let's send it to Ann.
Thanks, AJ. Hi, everyone. For those of you who don't know me, my name is Kate Copen, and I'm a labor and employment attorney in our St. Louis office. And above me is Ann Mayette, a labor and employment attorney in our Chicago office. We and our colleagues, Randy Thompson and Damia Park, are going to spend the next 20 minutes or so talking about practical lessons for defending charges of discrimination filed with the Illinois Department of Human Rights and the Missouri Commission on Human Rights. Both Illinois and Missouri have seen some changes to this charge process over the past couple of years, so we want to make sure you're all aware of those changes. And for employers located in both of these states, we also want to highlight some important differences between the charge process in Illinois versus the charge process in Missouri. So Ann, why don't you get us started on an overview of the charge process in Illinois?
Absolutely, thanks Kate. So as Kate stated, today we'll be talking about practical lessons for defending charges in Illinois and Missouri. Kate and I will be touching on the key changes to the law in Illinois related to the path of a charge when a charge of discrimination is filed with the Illinois Department of Human Rights. And I just want to note here before we really dive into the path of a charge that you will hear us refer to both the Illinois Department of Human Rights and the Illinois Human Rights Commission. The Illinois Human Rights Act, the act which the Department of Human Rights and the Human Rights Commission enforce, created 2 separate administrative agencies with distinct functions to enforce the act. The Department of Human Rights investigates charges of discrimination, while the Human Rights Commission adjudicates complaints of civil rights violations through an administrative law judge. So turning back to the chart here, you can see the path of a charge in Illinois starts when the charging party files a charge. The parties can then voluntarily mediate or settle, or the respondent employer can then answer the charge. Next, the IDHR will investigate the charge, hold a fact-finding conference, and then issue a finding. After a finding is issued, the parties can accept the finding by the IDHR or pursue an appeal in the circuit court. If the parties elect not to pursue an action in civil court, the parties will move to the conciliation process if there's a finding of substantial evidence of discrimination. If there's no finding of substantial evidence of discrimination and a dismissal is entered, the charging party may then appeal the decision with the Illinois Human Rights Commission or by filing a civil action in state court. So this is the path of a charge in Illinois according to the recent changes in Illinois. As you can see, it all starts with the proper filing of a charge. So I'm going to turn it back over to Kate now to discuss how the recent changes to the Illinois law affected the charge filing process.
So like Ann mentioned, Illinois law was recently changed to allow individuals a longer period of time, specifically 300 days, to file charges of discrimination with the Illinois Department of Human Rights. Individuals used to have only 180 days from the alleged violation to file a charge. And this 180-day deadline created some confusion because individuals in Illinois had 300 days to file a charge with the federal EEOC. And as many of you may know, the IDHR automatically cross-files eligible charges with the EEOC, meaning charges that state a claim under both Illinois and federal law are dual filed with both agencies. So under the old 180-day rule, a charge based on the same conduct could be timely before the EEOC, but untimely before the IDHR. An additional confusion occurred when charges contained some allegations covered under both state and federal law, and some allegations covered under only state law. For example, charges filed against small employers might be covered only under state law because some federal laws, for example, the Age Discrimination in Employment Act applies only to employers with 20 or more employees. Also, charges against individual managers or supervisors generally are covered only under state law. But now all of this is simpler. Regardless of how many employees you have or what the specific claim is, individuals in Illinois have 300 days from the alleged violation to file a charge. And while it may be a good thing that there's less confusion, this ultimately means as employers, you'll need to defend against more charges that previously would have been dismissed as untimely. So now we're going to pass it off to Randy and Damia to give an overview of the life of a charge in Missouri, but Ann and I will be back in a bit to talk about the next steps in the Illinois process.
All right, thanks Kate and Ann. Good morning everybody, this is Randy Thompson. Damia Park and I are going to be talking to you about the other side of the river, the life of a charge in Missouri. For those of you who have handled charges in Missouri, at least in recent years, you've probably experienced a lot of turmoil and a lot of back and forth in the courts with how the charges are processed and trying to defend against untimely charges. Well, as part of the 2017 amendments to the Missouri Human Rights Act, one of the other changes that was made was to streamline the process. And in most cases, these are very favorable for employers. So they added protections on defenses in terms of the timeliness of charges. There's limitations on the notices of right to sue, and the whole process is just a little bit more streamlined and largely should avoid court action. So we're going to walk through starting with the filing of a charge and just kind of walk through the changes that have been made and just reiterating some of the normal processes that haven't changed in there. So with that, we'll get started. I'm going to throw it over to Damia, and she's going to talk about the filing of a charge.
All right, thanks, Randy. So let's talk about the filing stage in Missouri. So in Missouri, employees who believe that they have been discriminated against must file a verified complaint, which means in writing, under oath, or affirmation within 180 days of the date of the alleged discriminatory act. But what if an employee fails to file a charge within that 180-day time period? Of course, we want to raise the timeliness issue to dismiss the charge, right? But prior to the amendment, there was a procedural problem that made life difficult for employers. So to be specific, if an employer were to raise the timeliness issue, the employer had to challenge the issue with the MCHR and also petition for judicial review with the court. If the employer did not pursue the issue through both avenues, then it completely lost its ability to challenge a late filed charge. So this process was widely different from the process for EEOC charges. So in order to streamline this process, the amendment made this timeliness issue a jurisdictional prerequisite to bringing a lawsuit. So now if the employee does not file a charge within 180 days, Missouri courts lack jurisdiction to hear a lawsuit, and also MCHR, it doesn't have any jurisdiction to investigate the charge or take any action other than dismissal. So what does this all mean to the employers? it's good news. Employers may now raise the timeliness defense at any time.
Yeah, this is great news for employers because there was nothing more frustrating than when you had an untimely charge and you risked either waiving it or you had to incur the time and expense of pursuing it potentially, all the way through the judicial action. So this is great news. And what's even better is you can't waive this, at least in the general sense of you can bring it up at any point during the proceeding. So it doesn't have to be brought up just in the charge process. You can also bring it up as a defense and as part of a potential motion to dismiss in a lawsuit. So this is great news and kind of putting it back to where things should have been from the start. Kate and Ann, we'll send it back to you now.
All right, thanks so much, Randy and Damia. So once a charge is filed and it's determined that it was filed in a timely manner, then the path of a charge moves into the pre-investigation stage. In Illinois, prior to the amendments to the Human Rights Act, employees could only request a right to sue from the Illinois Department of Human Rights if the agency determined that it would not be able to complete its investigation within 365 days. Under the amendments, employees can receive a right to sue from their employer from the IDHR immediately after filing the charge without having to wait for the investigation to be completed. Under these amendments, within 10 days of an employee filing a charge, the Department of Human Rights must send a notice to the employee giving her notice that they have the right to opt out of the investigation and commence a civil action in state court. To opt out, then the charging party must submit a written request to the Department of Human Rights within 60 days after receiving that notice, requesting to opt out. Unfortunately, this timing of when employees must decide whether or not to opt out of the investigation under these new amendments does not favor employers. Employers have 60 days from the receipt of the charge to file their position statement and respond to the questionnaire. Practically speaking, this means that the employer is going through the process of preparing the position statement, responding to the questionnaire, and doing all of its due diligence without ever knowing whether or not the employee is going to choose to opt out of the investigation process. If the employee does choose to opt out of the investigation process, and it does so within the 60-day period, the Illinois Department of Human Rights is then required to respond to the employee's opt-out request and notify the employer that the employee has opted out. Once the Department of Human Rights responds to the employee's opt-out request and issues the right to sue, the employee then has 90 days to commence their action in circuit court. If the charging party doesn't opt out, we go right back to the path of the charge, and the charge continues into the investigation stage. So now I'll turn it back over to Kate to discuss the process for responding to a charge.
Thanks, Ann. So within 60 days of receiving a perfected charge of discrimination, the employer must submit two things. One, a position statement, and two, a response to the IDHR's questionnaire. So the position statement is the company's response to the allegations in the charge. It's where you provide relevant background information and the rationale to support the company's side of the story. The questionnaire is often a 4, 5, 6-page document that requests general information about the company and its employees, often a copy of your most recent EEO report, personnel files, various policies, job descriptions, information on comparator employees. You can certainly object to the request if they're overly broad or not relevant to the underlying charge, or if it would be unduly burdensome to provide the information. Keep in mind the Illinois Human Rights Commission does have the authority to issue a subpoena if you improperly withhold information that truly is relevant. But remember, the documents you produce in response to the questionnaire and your position statement remain confidential and are not provided to the charging party. So those of you who have been responding to charges for a while in Illinois will recall that there used to be a third document that you would need to submit in response to a charge, and that was the verified answer to the charge. This also used to be submitted within 60 days of receiving the charge, and similar to an answer in a lawsuit, you would have to go through and admit or deny each allegation in the charge, and a company representative would need to sign the answer and verify under penalty of perjury that everything was accurate. And if you did not deny an allegation within the 60 days, it would be deemed admitted for purposes of the investigation, and the IDHR really didn't issue extensions for that either. Well, now under the new rules, submitting this answer is generally optional. So unless the allegations in the charge are very short and pretty much just legal conclusions, there's no real benefit in submitting a verified answer. Now, keep in mind that the IDHR does have discretion to require an employer to submit a verified response if you fail to provide relevant information or fail to cooperate in the IDHR's investigation. But generally speaking, you're not going to have to do the verified response anymore. So now we'll turn it back to Randy and Damia to talk about these issues under Missouri law, and then Ann and I will come back one more time to wrap things up in Illinois.
Thanks, Ann and Kate. So now we're back to Missouri. Let's talk about a few things that we should be aware of at this pre-investigation stage in Missouri. So Randy, I know that before the amendment in Missouri, a right to sue notice was typically issued with the MCHR's determination. So employees didn't really have to ask for one to file a lawsuit in state court. But if you look at this example notice we received before the amendment, it says, because you are entitled to disagree with MCHR's decision of no probable cause, the MCHR is nonetheless issuing you this notice of your right to sue. So how did this change after the amendment?
Yeah, thanks, Damia. And this is what I was talking about, where I think this is probably the most significant change and positive for employers. The right to get, the ability to get a right to sue notice is now much more limited than it was before. So whereas before, which you alluded to, Damia, where if for example, the commission issues a no probable cause, they will send a right to sue notice as part of that process. Well, that is no more. Under the amendments, once a decision is rendered, either to find probable cause or to not find probable cause, that eliminates the complainant's ability to get a notice of right to sue. So effectively what that means is if a decision is issued, probable cause or no probable cause, it will prohibit a complainant from ever filing a lawsuit in court seeking relief under the MHRA. They may have claims under other laws, but not under the MHRA. So that's great news. Also, the ability for the complainant to request the right to sue is limited. So you might think, well, why wouldn't a complainant just immediately request a right to sue to prevent the inability to pursue a lawsuit? Well, under the amendment, you cannot request a right to sue until two things happen. One, a minimum of 180 days has passed since the charge was filed, and two, at that point, the commission has not made a decision, so has not rendered a cause or no probable cause decision. So effectively what that means is if the commission renders a decision before 180 days after the charge is filed, no right to sue can be issued, which means no lawsuit can be pursued under the MHRA. And interestingly, the regs for the MCHR indicate that the commission is supposed to render a decision within 100 days, not 180 days. So theoretically, the commission is supposed to be issuing decisions before that 180-day mark. But of course, just as the case before, that's not happening. So we don't expect that to happen. But it does give some incentive if you think that there will be a no cause finding to supply a response very quickly and hope to garner a response from the MCHR as soon as possible.
Thanks, Randy. That was very helpful. So I'll kick it back to Ann and Kate again to discuss investigation and determination process in Illinois.
All right, so now that we've gotten through the filing and pre-investigation stages of a charge, the process then moves to the investigation and determination phase. In Illinois, the Department of Human Rights holds that what it calls a fact-finding conference as a part of the investigation. The fact-finding conference is a meeting conducted by the investigator, and the goal of the fact-finding conference is to complete a thorough investigation or have the parties come together and see if they can voluntarily settle, given the opportunity to present its side of the dispute and respond to the opposing side. We should note here that failure to attend the fact-finding conference without a good reason can result in the dismissal of a charge or in default for the respondent employer. Each party is allowed to bring legal counsel, but you should know that it's a strictly advisory capacity for your attorney, and they are not allowed to ask questions. All the questions will be asked by the Department of Human Rights investigator, and that investigator will then give the parties the opportunity to go back and forth to respond or rebut the other party's position and present any documents or testimony that they think supports their side of the case. You will see during the fact-finding conference that the investigator will be taking informal notes of the statements, but there isn't a reporter, nothing is being recorded, and the parties, will not get a copy of those notes because this is an informal process. So once that fact-finding conference is complete, the Department of Human Rights then makes its determination, and I'm going to turn it back over to Kate here to discuss the process once a determination is made.
Thanks, Anne. So like Anne said, at the end of its investigation, the IDHR determines whether there is, quote, substantial evidence that the alleged violation was committed. So the IDHR issues this determination in a somewhat lengthy report with findings of fact and conclusions of law and their reasoning behind its determination. So if the IDHR determines there is not substantial evidence to support the allegations in the charge is dismissed, and the individual has two options. She can either seek review of the dismissal before the Illinois Human Rights Commission within 90 days, or she can file a lawsuit in Illinois State Court within 90 days. It's one or the other, she can't do both. On the other hand, if the IDHR determines there is substantial evidence that a violation was committed, the individual has three options. One, she can commence a lawsuit in Illinois State Court in 90 days. Two, she can file a complaint with the Illinois Human Rights Commission within 90 days. Or three, she can request that the IDHR file a complaint on her behalf with the Illinois Human Rights Commission. Again, she just must choose one of those three options. If she chooses the third option, to request that the IDHR file a complaint on her behalf, she has to do this within 30 days of receiving that dismissal notice. But before filing a complaint on an individual's behalf, the IDHR will first initiate a conciliation process. In other words, an IDHR staff attorney or mediator will be assigned to help the parties try to resolve the issues through settlement. This conference is confidential. The IDHR cannot disclose the parties' settlement discussions without their approval. And the conciliation process does not stay or extend the 90-day deadline for the IDHR to file that complaint with the commission. So if the parties can't settle, they'll go ahead and file the complaint. So that pretty much sums up the life of a charge in Illinois. But before we wrap up the process in Missouri, Anne is just going to very briefly point out some related, new, and important changes to the Illinois Human Rights Act.
Thanks so much, Kate. So as you can see, there's been some important changes to the path of a charge in Illinois. There's also been some important changes to the definitions of the Illinois Human Rights Act that expand employer liability. In particular, the Act now applies to employers with just one employee. It applies to contractors, consultants, and independent contractors. In addition, the amendments expanded the definition of unlawful discrimination and harassment to include discrimination or harassment of a person based on his or her actual or perceived protected characteristic. And lastly, it expanded the definition of working environment to not just the physical office, but if duties occur outside the office. And now I'll turn it back over to Randy and Damia.
Yeah, thanks, Anne and Kate. So now let's talk about the investigation and determination stage in Missouri. So after we employers file position statements in response to charges, and then what happens? So the MCHR is saying that the investigator who acts as a neutral fact finder may interview witnesses, gather and review documents, and write an investigative summary. But we haven't really seen this happen very often. Actually, it rarely happens. So we can say the assigned investigator may or may not request witness interviews and additional documents or information. So Randy, so what happens after the investigation?
Yeah, thanks, Damia. So as Damia was alluding to, as opposed to Illinois, where the predetermination process is a little bit more structured. In Missouri, it's not so. And in our experience, at least with the Missouri Commission, we find that once in a while they may want to have an interview or talk to some people. but really no more than that. Once in a blue moon, they may want to do a site visit, but we tend to see that a little bit more from the EEOC than we do from the MCHR. So the process is typically, a little bit more concise and a little bit less involved. Now, as I said before, once they make a determination of cause or no cause, a right to sue can't be issued. So at that point, we're not looking at what we used to see, which was, regardless of the determination, a right to sue would be issued. That doesn't happen here. So if there's a determination of no probable cause, like you see on the screen, you don't see any reference to a right to sue. What you do see is the notice that's provided to the complainant that if they disagree with the decision, they can appeal that to circuit court. But that's just appealing the no probable cause decision. That's not pursuing a lawsuit. If there is a probable cause decision, then it goes through the normal process of pre-amendment. So at that point, the commission will engage in conciliation efforts and try to resolve the case. And if successful, they'll reach an agreement in that regard. If they are not successful, then the matter can proceed to a public hearing. And if it proceeds to a public hearing, then the commission will hear the case and can make findings of fact and can order relief, and that could be monetary and non-monetary in nature. Now, again, those are rare. I can recall a couple in 25 years that I've been involved in, so it doesn't happen that often. Do I expect it to increase now? Maybe slightly with the amendment changes, but otherwise, really the benefit again is that it's not going to lead to a lawsuit if there's a determination that's made on that. All right. Well, thanks everybody. Hopefully you found that helpful, and hopefully it was good to deliver, I think, what's a little bit of positive news this morning. So with that, we'll throw it back to AJ.
Thank you, Randy. And that takes us to our second poll question of the day. And that question is, has your organization experienced a decline in the number of charges of discrimination filed against it since the MHRA amendments went into effect? Of course, your options are yes, you have noticed a decline, no, things have more or less stayed the same or maybe even gotten an increase, or this question is not applicable to your organization because you do not have operations in Missouri. Thank you all for your responses, and you can see how your experience stacks up against those of your fellow attendees. It will be interesting to see if any sort of trend with charge of discrimination continues, especially once operations for most employers return to some normalcy after the pandemic. And now it's time for the second of our 2 breaks today. And this break is scheduled to be about 10 or 15 minutes, but since the breaks are my chance to be on screen talking to you, who are we kidding? It's probably going to be the full 15. So feel free to step away if you would like. But if you want to stick around, again, we have some more of our greatest hits from seminars past of the humor that we've presented. And again, I hope that for those of you who are joining us maybe for the first time, or the first time in a long time, that these presentations are new and entertaining to you. And for those of you who have joined us in the past in our live seminars, maybe these presentations are things you remember. Maybe they give you that little sense of nostalgia, that warm, fuzzy memory of sitting in a hotel ballroom that was far too cold or far too warm, and eating a quiche that was just the right size, and getting to see us all together. And hopefully we'll have that opportunity again soon. Next up, we're going to go back to October 2015 and show some excerpts for a presentation that we gave on something that is a difficult part of any HR professional, in-house counsel, organizational leader's job. And that is having tough conversations with their employees, telling an employee or group of employees something that they don't want to hear. And we thought it'd be helpful for you all to see some practical, sort of time-tested examples of how we at Husch Blackwell have managed to make those tough conversations just a little bit easier. One way that I think is very effective for delivering difficult news to your employees is by packaging up in a way that it will excite them and provide them some joy, at least in the moments before they get that news. And certainly everybody enjoys the experience of coming back to their office, finding a surprising bouquet of flowers on their desk, as Carrie has here. They look beautiful. They smell wonderful. And inside, you can put whatever note or information you need to pass along. For example, this is how we decided to let Carrie know that she was no longer going to be eligible for overtime. This is where I, as a wage and hour lawyer, have to mention that as attorneys and professionals who are using an advanced degree in law, we're not actually eligible for overtime anyway. And that's even if we don't comply with the salary basis. But I digress. Because providing this news from management to Carrie in this form, we ensured that, yeah, it may be difficult, but at least she had some beautiful flowers to save and to enjoy after getting that news. Or not. And here we have Terry Potter demonstrating another way to deliver bad news to an employee in a way that hopefully softens the blow and makes the experience a little more enjoyable. Who doesn't want Terry Potter arriving in their doorway, carrying a cake, giving it to you, experiencing that excitement, thinking, Terry finally remembered my birthday this year. But then you get a closer look at the cake, and you realize that, in fact, Terry is finally putting into writing that warning that he was delivering to you earlier. And as HR professionals, this is a quick note that if you do use a cake to deliver some sort of formal discipline or written warning, you're going to want to keep a second copy of the cake in a file somewhere that can be used if it's ever needed as an exhibit in later litigation. The nice thing about the cake method, of course, is that after the information is delivered, unlike flowers that may go in the trash, at least the employee can take a moment to eat their feelings. Next up in our tips and tricks on how to deliver bad news is a scene from my own home office when I was given some difficult news.
Oh, hello, Edith. Is that something for me? Thank you. Dear AJ, we are cutting your salary in half. Sincerely, the company. Edith, that's terrible news. But I can't stay mad at you in those kitty cat pajamas.
And I have to say, in addition to being adorable and feeling old, seeing how young she was there, my real takeaways from this video are actual practical tips that you think you can learn from the way that my daughter Edith handled that particular episode. And that is, she came in, she gave me the information, and she didn't say anything more than was necessary. And the minute that the news had been delivered, she got out of there. I think we can all learn quite a bit from that. And finally, in our series of practical tips on how to deliver difficult news to your employees, we have a series of videos here that will show you how to leverage, sort of the growing capabilities of artificial intelligence and the smartphones and devices that our employees have, and finally allow that, the robots to do some of the dirty work for you.
Siri, what's the weather going to be like this weekend?
The weather this weekend will be beautiful, Brian. But that won't matter for you because Mr. Smith needs the revised Vandalay report by Monday morning. Try not to screw it up again.
Siri, call Mother's cell.
Brian, are you sure it is a good idea to make a personal call in the middle of the workday? You are already on thin ice. If I were you, I would get back to work.
Siri, give me directions to work.
I am glad you are sitting down, Brian. I have some bad news. You won't need directions to work this morning or ever again, because the company has decided to go in another direction. We wish you luck in all of your future endeavors. Rerouting to unemployment office.
Brian Stair, who was just given all that bad news by Siri, is another of our former Husch Blackwell attorneys who appear in these videos as we throw it back to the good old days. And I can assure you that Brian was not actually terminated as a result of those videos. This was, a bit of fiction, just for educational and informational purposes. And I can also assure you that, being told he was fired, by Siri is not the worst thing that you're going to see happen to Brian during our throwback to. Next up, we take you to May 2016. and a series of videos and pictures and clips that will hopefully help you learn a little bit about how to overcome workplace embarrassment. It may not be a surprise to you to find out that the attorneys at Husch Blackwell, and particularly one of whom is speaking to you right now, gets embarrassed at work pretty regularly, but I think I've come up with a number of different ways to sort of handle that and make it, go pretty smoothly. So first up, I'm going to take you through a strategy that I have developed to, deal with a common embarrassing situation that happens to me. And actually, as I look at this slide, it hits a little close to home because embarrassment number one was actually my dad's nickname for me growing up. But my dad, who knows me well, and anybody else who knows me well, they know that I enjoy a nice cup of coffee. And I actually, drink from a cup of coffee regularly throughout the day. And every once in a while, I spill a little bit of coffee onto my nice white shirt. And I know many of you are thinking, well, this is an easy fix. You just need to keep, a clean shirt in your office and trade it out if you spill something on it. And that's great, but I drink 3, 4, maybe 5 cups of coffee a day, times 5 days a week. We're talking 20, 25 clean shirts that I've got to keep in my office. That's just not feasible. So instead, I came up with what I think is a pretty innovative way to deal with the problem. And the solution that I came up with, relies on the fact that, the embarrassing situation here is not so much that, there's coffee on my shirt. It's the fact that you can tell that there's coffee on my shirt. So here's how we fix that. All you have to do is take the shirt off, go into your break room, and cover and soak the rest of the shirt in coffee. Right? Wring it out to dry, hang it up in your office, and when it's dried, you flip it back on, because now you no longer have a white shirt with a brown stain. You've got a brown shirt with no stains. And you can go about kicking up your feet and having all the conversations you want. And then, of course, we can deal with the embarrassment that goes along with that brown shirt and black pants later. Next up, we're going to see how Joe Glinius handles an embarrassing situation that actually is all too real and too relevant for each of us in our lives during this virtual work-from-home time.
Good morning, everyone. This is Myrtle. Welcome to our morning update call. Who's on?
You've got Joe from Legal.
Pamela from Inside Sales Northwest.
Bruce from Outside Sales Southwest.
Art Vandalay from Internal Outside Sales.
Terry on for Janet from Oversight.
Dominique with Tricia, Maria, and Lyle from Event Coordinating.
Hi, this is Kevin T. from Support Logistics. Hi, this is Kevin C. from Logistical Support.
Okay, great. That's everyone. Let's get started. As we enter fiscal year 17 Q1, it is going to be imperative that we take a helicopter view of our success parameters in order to identify and pick off the low-hanging fruit.
She's a rich girl.
While not losing sight of the high-hanging
anyway.
Hey, who's singing?
On your... Oh. What? I'm sorry.
Oh, nothing more embarrassing than forgetting to have the mute on your phone. And not only is that embarrassing, but I imagine not too many of you were thinking you would hear not one, but 2 attorneys from Husch Blackwell sing today during the seminar, but there you have it. So we'll see, how did Joe come up with a solution to handle and get rid of that embarrassment? We'll take a look.
Who was that singing?
I'm sorry, Myrtle. That was me. Maybe I'm alone in this, but sometimes your direction of the division is just so inspiring that I sing a little. So I'm sorry. I can't help it.
Joe, I appreciate your honesty. That is the sort of attitude that's going to make this company a success. We need more people like you. Okay, where was I? Today, I'm not necessarily looking for a full-on
I never meant to call you. But it don't matter anyway.
An unbelievably savvy move by Joe, and an opportunity for you to hear 4, 5 more Husch Blackwell attorneys singing. Next up, we're going to see a short clip of how Scott Myers handled an embarrassing situation with a coworker. And for some context, when this was recorded, the St. Louis Blues had recently defeated the Chicago Blackhawks in Game 7 of the playoff series, which is both important to provide for context to this presentation, but also something that I enjoy saying out loud.
Hey, Scott. Did you see that Blues game last night?
I did. How about that? I think this is their year.
Game 7 wins. Fantastic. I hate to be a Blackhawks fan today.
I hate to be a Blackhawks fan. ever. So stupid, aren't they? It's so stupid.
Is there anything more embarrassing than all of a sudden and accidentally saying something about a coworker that offends them, right to their face? Sticking your foot, squarely in your mouth. And it's something that probably won't surprise too many of you to know that I do that, kind of regularly. So how did Scott solve this particular problem? What was he going to do? How do you walk it back from saying something that was so plainly offensive to his colleague, Brian? Let's take a look.
Oh, I'm sorry, Brian. I didn't know you're a Blackhawks fan.
Can I see that mug real quick? Thanks. Go Blues!
Obviously, Scott showed us another very deft, very savvy way to take an embarrassing situation and pretty effectively diffuse it. But before any of you feel too bad, remember that Brian knew what to do next. Well on his way to curing himself of that embarrassment. And our final stop on our trip down memory lane from humor's past takes us back to November of 2017, when we put together a presentation about some of the Husch Blackwell St. Louis labor and employment attorneys' biggest workplace pet peeves. Because we were told by a marketing firm that making ourselves seem more relatable is something that would improve our standing with our clients. So take a look at what some of us said.
Kate, what would you say your biggest pet peeve at work is?
I have this coworker who always seems to be eavesdropping on our conversations, and then he always seems to find a way to insert himself and kind of one-up us. Wow, that's crazy.
I know, so now it's like my neighbor has 7 dogs.
You guys talking about dogs? I've got a neighbor down the street from me. He's got eight dogs. It's nuts.
That's great, AJ.
Yeah, wonderful.
And a lot of the times, I have a hard time even believing what he's saying is true. Yeah, so Randy, over the weekend, my grandma fell down the stairs and broke both her legs.
Oh my gosh, both their legs, that's horrible.
Yeah.
Oh man, you guys talking about your grandma? So over the weekend, mine fell on some ice, broke all 3 of her legs.
Yeah, it's gotten to the point where we are doing everything we can to stay out of earshot of him, but that doesn't seem to be working.
So I just had to tell somebody about this. I don't know if you watched Game 7 last night. It was an awesome game. I bet $100 on the team that won last night. Yeah, it was really fantastic. Yeah, pretty excited about it.
You guys talking about Game 7? Yeah, I actually bet $200 on the team that won, and I am really fired up about it.
With all due respect to Kate, I'm just not sure that I see what was so annoying about that person sharing such useful information. And also a little bit of candor sort of behind the scenes, after the fact information. This was filmed in November of 2017, and that green shirt was lost to a dropped slice of pizza at a meal maybe 1 week later. It's a little bit emotional for me to see it again. And we'll end today with one final clip from one of my colleagues, Carrie, talking about her biggest pet peeve at the firm.
Carrie, what's your biggest pet peeve at work?
Pet peeve? Huh. I know what it is. So we do this labor and employment seminar 2 times a year, and I've got this coworker. He has a habit of making the whole thing about himself.
Far be it from me to break any confidences with Carrie or to try to get her into any sort of trouble, but between me and the several, many hundreds of you out there, I'm pretty sure she was talking about Bob Tommaso there, and I do agree it can be a little bit annoying when he tries to make things all about himself. But that takes us to the end of our humor, and you'll get a chance hopefully next spring or next fall, whether in person or virtually, to see what we come up with next, or see if we punt again and just revisit some of the second best humor sessions that we've done in the past. But regardless, one thing I do know for sure is that we are headed next to our final presentation series of the day, where you're going to hear from Brittany Falkowski, Julia Farrell, Kayla Lovelace, and Scott Myers as they discuss some strategies for leveraging those virtual capabilities that you have grown over the last few months and how to continue using them after your workers return to the office. And we will send it out now to Brittany.
Thanks, AJ, and hello, everybody. My name is Brittany Falkowski, and joining me today is Kayla Lovelace. We are both labor and employment attorneys with Husch Blackwell in the firm's St. Louis office, and we are presenting today, though, from our respective home offices. Our last presentation of the day is about leveraging virtual capabilities with your workforce now and into the future. And as we were preparing for this presentation, one of the things that we all thought was pretty interesting was just how popular Zoom has become in a matter of really just mere months. And I don't know about all of you, but I had never heard of it before March, and now it's on literally every single one of my devices. It's become kind of like the word Google in our vernacular, in that it's not just a proper noun, but it's also become a verb and an adjective. And in addition to using it for work, I know I've been using it for baby showers and game nights and happy hours, and it's been really great for staying connected while we've all been staying home. But as many of our clients are telling us, and as I know Kayla can attest, we've been experiencing somewhat ourselves, there have been some challenges too. So rather than explain those challenges, we thought we might show them to you.
All right. Talk to you guys soon.
Bye.
See you guys.
Tony!
Can you hear us?
Tony!
Oh no! Don't. Jen, call him. Oh my gosh! Hold on, I'm gonna text a couple pictures of that. Oh. Oh. Oh boy.
What's up? Tony, I can see you when you're
We can all see you.
Cold air continues across the area tonight. Potential for some frost and freeze for some of us. Warm up, it's going to take... Hey, hey, come here. Come here. Come here. Sit. 3, 2, 1. Frost and freeze for some of us again tonight. The cold air is lingering through much of the week. We'll show you when the best chance of precipitation is with Futurecast. Maple.
Thanks, Connor. Mommy's trying to do a little bit of work. Can you let me finish my work? Hey, let me open them. Go upstairs so I can finish my work, okay? Hey, I got to record something real quick, okay? No, he's on the phone. Just give me 5, okay? I know, I need 5. He is on a call, okay? You cannot talk to Daddy right now. Give me a second, guys, okay? Go upstairs. 3, 2, pulling water rise. Guys, go upstairs with a critical. Connor, give Mommy a minute, please. I'll be upstairs in 1 minute. 3.
In all seriousness, things are really going well for many of our clients. Work from home has allowed many companies to successfully continue their businesses. Many offices have leveraged online platforms like Zoom, like Brittany mentioned, to connect their employees and to allow their employees to maintain productivity. In fact, Husch Blackwell recently opened an online-only branch of our office called The Link. We believe that we will see many benefits from The Link, including staying connected to our clients and our peers on a whole new level. We're very interested in hearing about the experiences of our clients and those of large corporations generally. For that reason, Brittany and I have put together some statements made by high-level executives of large corporations. Although these executives have differing viewpoints of the benefits or the pitfalls of working from home, they all seem to recognize that there will likely be lasting changes in the way that we work as a result of COVID-19. For example, Tim Cook from Apple, he stated that he does not believe we will ever return to the way things were because there are some benefits from working from home. Along that same line, Dana Kennedy from Simon Schuster has also stated that she believes that there will be permanent changes to the way that we work.
Right, and just to round this out, here's one more quote from a pretty recognizable CEO who has also been embracing changes that work from home has brought. In fact, Warren Buffett recently indicated that the pandemic, he thinks, is teaching us that business can be conducted in new ways, and when change happens in the world, you just have to adjust. So the rest of our presentation is going to be about just that, ways in which we can adjust on a go-forward basis to use what we've learned during this time to our advantage. And so with that, Kayla and I are going to kick it over to Scott and Julia to discuss leveraging virtual platforms when conducting employee meetings.
Thanks, Brittany. Hello, everyone. My name is Scott Myers. I'm an associate in the L&E group in St. Louis, and I am here along with my colleague, Julia Farrell, a partner in the L&E group in St. Louis. We're going to talk to you now about how to leverage virtual meetings to your advantage while still being mindful of the related legal concerns. So, virtual meetings, they've really become a part of the workplace now that really didn't exist, at least with any regularity, only 6 months ago. And so you've really got a unique opportunity to kind of leverage these capabilities that everyone has now and take advantage of the different, technological systems that we have at our fingertips. I think it's really going to make a difference on some of those employers that take advantage of this, capitalize on the technology versus those that don't. You may see a real competitive advantage in the labor market. Some of the things on how you can leverage these are pretty obvious. Easier scheduling. In the past, you had to get it at a time where everyone was in the building at the same time. You had to reserve a conference room, perhaps in your office. Everyone had to come together so you could have your meeting. All of that's out the window now. You really just have to make sure everyone is available and in front of a computer at any time of the day, and everyone can kind of get into these virtual meeting rooms together. And also, we have this interactive technology that maybe don't exist in the conference rooms in your office. Not every office is up to date with cutting edge technology, but these platforms now where you can share screens, you can do graphics, stuff that wasn't always easily available in traditional settings. So those are some of the good things, some of the positives that come along with these virtual meetings. But of course, there are also these legal issues that you may not realize are in play when you're having virtual meetings. And so Julie is going to introduce some of the context to those legal issues that's going to help us guide our discussion today.
That's right, Scott. We've done a little bit of research to the extent it's available to us in this virtual world that we're all living in now. And it's been kind of interesting. One of the studies that was done by the American Lawyer looked at how virtual meetings impact gender bias issues. And one of the issues seems to be that women are reporting that this virtual setting can disproportionately affect them. In fact, the survey reported that almost half of the women who were surveyed indicated that they felt that they were unable to speak up in a virtual meeting. Now, this is something that we've been talking about for years with regard to gender bias and meeting contexts, man speak, all these types of things. But this format that we're all living in now can actually exacerbate the problem. More concerning, we've had more reports and the surveys have shown more instances of folks feeling like they are being discriminated against in a virtual world. And you might be asking yourself, how is this possible? I mean, we're not even in the same room together. How is there more discrimination going on when we're all appearing virtually? And I think it could be a couple things. I think on one hand, sometimes people may feel more emboldened when they're making comments through a screen or a keyboard that they otherwise wouldn't be willing to do in person. I think also people feel more casual in a video setting. A lot of us are appearing from home. A lot of us are appearing with more casual appearance than we would ordinarily wear when we're at work. And that can just lead to some inappropriate comments that employers may need to be concerned with. Another issue that we've been looking at, and we've talked about this in some of our earlier presentations, is the caregiver bias issue. And caregiver bias obviously has been a big problem and perhaps a concern with regard to female employees, especially now that we're living in this virtual world. But there's a concern that when we're having virtual meetings, that there are assumptions that are raised about female employees, that they are unable to be present for the meeting because they have childcare concerns or other things that are keeping them from the meeting. I actually heard an anecdote just recently about a phone call that was to take place on a case, and there were several people on the call, some of them men, and one of them was a woman. And the organizer of the call decided that since the call was taking place at 5:30 in the evening, that he would leave the woman off of the call because there was an assumption made that she had childcare responsibility. And the interesting part about the story is that the person who reported it to me was a man who also had childcare responsibility, and that assumption was not raised with regard to him. So it's just something that has come up that we need to be aware of. And it's something that employers need to take active steps to prevent and address if it becomes a problem in their workplace. So, Scott, what can employers do about this?
Thanks, Julia. So, yeah, there is, what Julia just went through is that there are a lot of concerns in the workplace about how people are adapting to this new virtual workplace. And there are a couple things you can do to make sure that you are not one of the companies that falls victim to having this transition go unsuccessfully. First thing would be conduct a workplace survey. The statistics Julia just showed us, those wouldn't have been possible without people actually going out, asking the questions and getting those responses, especially, could be surprising responses like that. When you're doing a survey, and you're getting the pulse of your workplace, you're probably going to be asking difficult questions, things that people may not be comfortable answering if they're going to be having to have their name attached to them. So the most important thing when conducting a survey is to offer anonymity. If someone is able to give a response and they know that it cannot be tracked back to them, that they will not be, they don't have this fear of retaliation if they give certain information, then they are much more likely to be honest and forthcoming with what they feel like is going on, what their experiences are. Again, you are going to be asking about potentially difficult topics, things that is very helpful for you as an employer to know, but in order to get that, you've got to give that employees that layer of protection. It's also important to use a secure platform. You're not just handing out a piece of paper and having someone check some boxes and then turn it back in or anything like that. There are a variety of secure survey platforms that are designed for employers to poll their employees. If you have any questions about what those may be, you can always reach out to us for recommendations and we can let you know some of your options. Okay, so now that you've done your workplace survey, maybe you have an idea of some of the concerns people have with working from home, conducting meetings virtually. What are you going to do with that information? That information is only useful if you actually act on it, but just having the knowledge doesn't really make that much of a difference. It's always good to have a nice, robust video conferencing policy. It's not something that a lot of companies thought they needed a few years ago or even a few months ago, but now with the position we're in, it's definitely something you need to look at. The number one thing, have your anti-discrimination, your anti-retaliation, and your anti-harassment provisions in those policies. People need to understand that the same rules apply in a virtual meeting that would apply in an in-person meeting. Julia hinted at it before as to maybe one of the reasons why we're seeing upticks is because some people feel emboldened to say something through a keyboard that they wouldn't say face-to-face, or they may feel like it is a more casual setting, so they can comment on someone's appearance because they're just seeing, their head on a video screen in it, and they're just trying to make small talk. Stuff that wouldn't happen in a regular meeting, we're seeing happen in virtual meetings. You need to make clear that these same rules and expectations apply in a virtual workplace as it does when you're at your physical meetings. For neutral dress codes and appearances, a lot of places have dress codes at the workplace. Maybe it's a professional setting. Well, you don't necessarily want to require someone to wear a suit and tie when they're working from home, but you also maybe don't want them showing up in just, a hoodie or something. You can have standards, just find that happy medium of what you want those standards to be, and then make sure that those are gender neutral. Don't have standards that just mention, really low cut blouses or spaghetti straps. Things that would appear like they're only applying to women. If you're going to have these standards, have them drafted neutrally, gender neutrally, so they apply to everyone. So you're not making more problems for yourself when you're really trying to solve an issue. And the last thing I want to talk about, cameras and backgrounds. A lot of employers want to require cameras to be on for virtual meetings as opposed to just turning a camera off or dialing in with a phone. More cameras lead to more engagement. But then you've got employees who maybe, everyone's just trying to make do right now. Not everyone has a nice home office. Maybe they're working in an unfinished basement. Maybe they're working in their bedroom. They don't feel comfortable having that in the background. Offer backgrounds. These platforms can give you a chance to have a corporate boardroom or can give you a chance to have, a blank color. Offer that as an option. Even you can let your employees make their own, but have standards with that. We've had issues of politically charged backgrounds, and we don't want to see, a lot of employers don't want to see any of that, especially at these times. So again, your policy should make clear what your standards are. But again, once you're requiring a camera, requiring certain backgrounds, you're going to start exerting a certain level of control over these individuals, and that can have some unintended consequences. So now I'm going to throw it over to Brittany to talk about what some of those unintended consequences may be.
Yes, that's exactly right, Scott. And one of the unforeseen consequences of having a remote workforce is that employers may have to reimburse their employees for expenses associated with those home offices. In fact, the more that an employer exerts control over the remote work environment, the more likely it is that the employer is going to be exposed to expense reimbursement requirements under both federal and state laws. So first, this slide refers to the Fair Labor Standards Act, or the FLSA, which is a federal law that applies to nearly every employer. A few months ago, the US Department of Labor issued some guidance about reimbursing employees, and specifically there was an FAQ that asked if employers were required to cover any additional expenses that employees may incur if they work from home. And the FAQ specifically mentioned internet access, an additional phone line, and even increased use of electricity. Now, the DOL didn't directly answer the question, but rather just said that employers cannot require employees to pay for business expenses if doing so would reduce the employee's wages below minimum wage. There are also a few states that have laws related to reimbursement requirements, and because this presentation is geared toward Missouri and Illinois employers, this slide also mentions Illinois' law. It's a relatively new law and there is not a lot of guidance on it, but we think there are really two important things to know. First, it's that it applies to employers in Illinois, and there's some case law that indicates that means if employers registered to do business in Illinois and those that have sufficient contacts, which would probably apply to anybody who has employees there. Second, Illinois employers have to reimburse employees for reasonable expenses required of the employee. So for both the FLSA and the Illinois law, we think that focusing on the word require is what's important. As employers, we have to ask ourselves, what are we requiring of our employees? First, do we even require that they work from home at all, or is it merely a perk that we're offering? And if it's a perk, then the analysis could be over. But if the employee's job is a fully remote position, then we have to ask at least a few more questions. Are you requiring employees to have dedicated office space with a chair and a desk, or can they work at their kitchen table? Are you requiring that they have a certain internet speed, or are you leaving that choice up to them? And the more that you're answering questions in the affirmative that you're requiring employees to have certain things, the more likely it is you're going to have to pay for those things under these applicable state laws. So this is obviously one potentially unforeseen cost of managing a remote workforce, but there are certainly plenty of benefits. And so I'm actually going to bring Scott back now to discuss some of those with us. Hello again, Scott.
Hello there.
Okay, Scott, so on our next slide, we have a quote from another CEO at a large US company, Rite Aid, and this quote relates really to recruiting a remote workforce. Hayward Donegan has said that her philosophy has always been to hire the best and the brightest, regardless of where they're located, but now, due to the pandemic, she's learned they can not only work remotely, hire remotely, but also manage their employees remotely.
Yeah, so a company like Rite Aid, she has said her philosophy has always been, as you were just alluding to hire their best and brightest, regardless of where they work. And that's kind of been an advantage that those large companies have had over the smaller, more localized business. But now with the virtual workplaces, small businesses have an opportunity to really gain some equal footing and become more of a quote unquote national employer, even if their operations were typically localized. Because really it doesn't necessarily matter if someone is sitting at their desk 4 states away if their job is going to be entirely virtual. This means that you can attend these virtual job fairs that we're starting to see pop up. You can really cast a wider net. Your recruiting doesn't have to just be the local universities that you may go to or the local job fairs. You can really do all of the things national employers would do without having to incur those travel costs. You can also use this as a way to increase diversity in your workforce. There are certain areas in the country where there might be more diverse candidates that you maybe have not had access to before. That is something that our clients have asked about, and this is a great opportunity for you to go ahead and capitalize on these opportunities. Now, of course, there are some challenges with having a widespread workforce from a legal perspective. So Britt, can you highlight what some of those challenges are for us?
Yeah, absolutely. Unfortunately, it is not all good news, but before you begin expanding your footprint across the country, there are some potential legal implications that you've got to carefully consider. State and local taxes, for one, as well as workers' compensation issues, are generally controlled by individual state laws. So you really have to understand the requirements of each state where you have employees working before setting up a remote office location. Second, while there are some unemployment tax rules that are out there for multi-state employers that help you determine which fund you pay into, there are also issues that could cause confusion, including when an employee splits their time between two states. For instance, somebody who may be working in a physical building in St. Louis but living in Illinois. And of course, there's just complying with other states' laws too that regulate employment issues, whether that's anti-discrimination statutes that have training requirements or wage and hour statutes that have different rules around paydays, what goes on a pay stub, and overtime. So as you can probably imagine, we have had a number of clients calling us lately because they're trying to walk this tightrope. They want to take advantage of the opportunities that you've mentioned, but they don't want to open themselves up to a bunch of legal liability. And so they've been asking us, can we say that we will only hire employees who work remotely in states where we already operate? So that way we know what we're getting into. And the answer there is probably yes. And we say probably only because there is a chance that if you strategically limit your footprint in a certain way, you may end up adversely impacting a certain group of people. And so you just want to be thoughtful about this decision, just like you would be any other employment decision. Okay, Scott, so we are going to switch gears just a little bit now, and we heard you and Julia talk earlier about using virtual platforms for employee meetings. I want to take it a step further and talk a little bit about employee investigations. Why don't you go ahead and give us some pros related to conducting investigations virtually?
Great, thanks, Britt. Yeah, I feel like I get to be, we're kind of got a good cop, bad cop here, maybe good lawyer, bad lawyer. I get to give all the good news, all the pros, and then Brittany gets to come in and rain on everyone's parade with the cons. So let's look at those pros first. I talked to you guys about this earlier when it came to meetings, about the limited travel and the scheduling. That just is always going to make investigations or meetings easier in the sense that you just have to make sure someone is in front of their computer at a specific time and don't have to get everyone in one room. Of course, this limits the option of an HR professional to do like a surprise visit. You can't really drop into someone's office anymore and not give them an opportunity to maybe come up with excuses as to why they're being investigated. So that was certainly a consideration to make when determining whether you want to engage in a virtual investigation. But perhaps the best part of a virtual investigation, I think, is the promptness that they can be completed with. A very common concern that we see with investigations is that they simply just take too long. And that can be a problem for a whole host of reasons, especially in future, if litigation were to arise out of an investigation. But with virtual investigations, without the burden of these scheduling issues, sometimes travel issues, you can really make it more streamlined and be able to come to a conclusion much quicker than you would in the past. But Brittany, again, there are some things to consider. It's not all good news. So why don't you tell us about those?
Sure, yeah. So at the risk of stating the obvious, if you have an investigation that's going to require a physical search of a file, desk, or locker, or a certain space, then that's going to be pretty difficult, if not perhaps impossible, to complete that portion of the investigation remotely. And I know Julia and Kayla are going to talk about this a bit, so I'm not going to belabor the point, but credibility can be really hard to determine. You also may not pick up on nonverbal cues the same way. And there are also just issues with the platforms. I know the other day I was actually trying to connect with a witness and it took him 30 minutes to figure out how to use Zoom. I'm not going to name names, but that kind of delay and really, the frustration that can cause somebody could have the potential to impact the interview. So even though some of these cons may deter people from using virtual platforms for investigations, there are ways to abate them. And so I will let you talk about the tips and tricks that we've kind of learned from the last few months in our virtual investigations.
Yeah, so this is more of kind of the practical advice, the things that we see you can do to make this go more smooth and potentially limit any issues you can have either legally or otherwise. You definitely want to choose the right platform. A lot of these are popping up everywhere now. Zoom is probably the most popular, but you do have other options. Just make sure that you're picking something that you understand how to use it. It is secure. You would want to have a screen sharing function. A lot of investigations may deal with certain paperwork or documents that you would want to have someone looking at as you're talking about it. Be sure that you can do that on whichever platform you choose. And the last thing I want to touch on here is probably the most important is the confidentiality and recording. Make sure someone is alone in the room, no one is there with them, and that if you don't want them to record it, make sure that's explicitly stated. That's pretty much the tips and tricks, and if you guys have any questions, you can always reach out to us. Thank you.
Thank you, Brittany and Scott. For those of us who spend most of our time litigating, this virtual world has meant a lot of change, and a lot of good things and a lot of bad things have come out of it. On the good side, we're able to conduct client meetings, prep sessions, depositions, hearings, and even arbitrations remotely. And it saves us time, it saves travel costs, and I think ultimately it saves our clients money. It's also easier for us to connect and see our witnesses quickly and easily. But there's downsides to it, and there are practical considerations that we've never had to think about before. You know, as it stands now, we don't really have a lot of choice in appearing virtually in litigation. Most courts have actually passed mandates that require us to do so. If the other side requests a remote deposition, we have to abide by that. But in a post-COVID world, we're all going to have to choose whether we want to litigate remotely. And there are some things, no matter what we do, that are better done in person. Jury trials are obviously one of them. Many courts have just suspended all jury trials. There have been a few brave courts that have proceeded, but mainly the focus in those areas where they have limited resources has been on the criminal docket. So for example, Riverside County, California, there was recently an article published about how they had conducted some 50 trials, but all of those trials were criminal trials. Obviously, there's a constitutional right to a criminal jury trial, and courts are going to prioritize the criminal cases. Very few cases have been tried, civil cases have been tried remotely. Realistically, what this means is that virtually every case that we have worked on, that I've worked on in the last 7 months that had a trial setting has been continued. So instead of this taking 2 years for a case to advance from filing to trial, it's now taking 3 years or maybe even more, depending on when we get out of this mess. So practically speaking, what does that mean? My personal experience is that sometimes this has actually been a good thing. We have no possibility of trial or resolution anytime in the near future. So we've had several plaintiffs who've come out of the woodwork wanting to settle a case fairly reasonably. I think they're looking ahead and wondering when their payday is going to happen. And when they can't see that, they think about settling the case. Sometimes it's actually been a bad thing for our clients. On those cases where settlement isn't a possibility, now we have, no matter how hard we try to budget, we have a case that's lasting longer. And the longer a case goes on, the more expensive it's going to be. So the longer time from filing is ultimately going to end up with higher legal costs for all of you. So virtual trials are something that we all as a legal community haven't quite figured out yet. But other parts of the litigation, like witness prep sessions, are happening virtually every day with mixed results. And Kayla, I know you've had some experience with that recently.
Yes, Julia. I have had some recent experience with preparing witnesses virtually. For the most part, I've had varying success, and really I've seen much of it depends on the witness and how much they have prepared for the meeting. So we've had some witnesses come to meetings before having refreshed their memory of the case. We've even had some refuse to turn their cameras on during our sessions. Additionally, we've had issues with lost or misplaced exhibits or exhibits that have been disorganized in the time that we sent them through the mail to the witness. For the most part, we noticed that preparing a witness virtually takes about the same time as it does in person. There is some additional prep time needed from the attorney to send the exhibits in advance, so that means we have to do our review further in advance. Additionally, for attorneys, it's harder for us to assess the witness's credibility virtually because we're not in person. For that reason, it's hard for us to say how a witness may present to a judge or jury. I'm sure these same things have happened in depositions, Julia, and I'm excited to hear about your opinion.
Yes, you're right. Some of the same things have happened, Kayla. And, we've always had the option of conducting depositions remotely. Generally, especially when I'm taking the deposition, I don't like it. I don't think you can be as effective. I don't think you can be as intimidating. I don't think you can effectively use exhibits, as you mentioned, Kayla. And again, now we really don't have any choice. We have to conduct them all remotely. I think when this is over, unlike jury trials, I think virtual depositions are going to become the norm. So practically speaking, we have some new considerations that we'd never had to think about before. For example, I've learned that we need to make sure that when we're deposing someone, we ask the deponent to identify everyone in the room. This seems like a real simple thing, but we've actually had situations where we're taking a deposition not realizing that the deponent has a spouse, or even another witness in the room. One of my colleagues told me a story the other day about a deposition that she took. The plaintiff actually appeared for the deposition on his phone in his truck, and about halfway through the deposition, she realized that there was another witness in the truck with him, and created all sorts of issues as you can possibly imagine. Also, counsel need to be a lot more cognizant of the hot mic issue. We all have dealt with this on virtual meetings where people cannot figure out when and how to hit their mute button. And this actually occurred on a deposition I took on Monday. We took a break and opposing counsel did not hit the mute button and then proceeded to call his client on his cell phone and have a 10-minute long conversation with his client that was attorney-client privileged about what had been going on during the deposition. I tried to notify him that the mute button was not on. I tried to get his attention, and when I realized he wasn't going to do anything about it, I actually turned down my sound and exited the room so that I wouldn't hear his conversation. But that can be a real problem with counsel waiving an attorney-client privilege if they're not careful to make sure that the mute button is there. So depositions are a little bit different now in this virtual world. We have to be a little bit more concerned about exhibits. And the idea that we could hold those exhibits close to the vest like we used to do in the past isn't always going to be possible for us. And I know some of these same issues have arisen when we've been in hearings and court appearances. Have you had any experience with that, Kayla?
Yes, I have had some recent experiences with court appearances and hearings. For the most part, I have been lucky, and each of the courts where I have appeared virtually have seemed to adapt really well to the new virtual world. Each of the court clerks schedule all the Zoom meetings in a timely fashion in advance so that everyone kind of knows what's happening. And also, my court appearances have been seamless for the most part with no large technical issues. I know I'm lucky in that capacity, and I'll be crossing my fingers and hoping that stays the same. We've appeared before judges all over the country from the comfort of our homes, as you can probably tell from my background. We've also been able to represent our national clients without ever leaving our home office, and I'm sure many of our clients appreciate that. Overall, virtual court appearances have really streamlined many parts of our practice. With that being said, that concludes our presentation, and with that, we'll throw things back your way, AJ. Thank you.
Thank you very much, Kayla. And with the completion of those presentations, it takes us to our third and final poll question of the day. And this asks, does your organization have a video conferencing policy that requires employees to have their cameras on? Yes for all meetings, yes for some meetings, or no, cameras are not required to be on for any meetings. Thank you all once again for your responses to this, our final poll question. And on a personal note, I do want to mention that I, for one, am a huge fan of clients and other folks at Husch Blackwell who have an expectation that our cameras are on for meetings. And that's not because I get to see them or you or connect on some more personal level, but rather if it weren't for those occasional video conferences, I would have no reason to have kept up on my grooming over the last 6 months, and I would look fully like a Sasquatch at this point. And with that final poll question, that ends our substantive presentation for today. And I'd like to thank you for joining us, and we have a few housekeeping items that we're going to discuss. And I'd also like to remind you that there is one more presentation in our webinar series that will be put on by my Wisconsin colleagues next week. And again, this and other programs will be available on demand. So don't worry, if you're worried about a winter of not getting to see us, you can click that link as many times as you would like. Oh, I see I'm being visited by somebody here. Hello, Edie Jo, what's up?
Oh, I'm sorry, Dad, but I just wanted to tell you you're a great dad and an even better lawyer, and I'm proud to call you Dad.
Oh, Edie Jo, that is a very nice, very unplanned comment that you have just made. Now, you'll see I'm almost finished with my presentation here, but if you can hang around and be quiet while I do some final announcements, maybe you can join us again on the last part here and say goodbye to everybody. Does that work for you?
Okay.
Okay, so we will all get a chance to find out exactly how much self-control my kids have as I read through these final reminders. So this program has been approved for HR and legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a link to a recording of the webcast for watching and sharing. Be sure to complete our short survey. We do use your feedback to plan future programs that are applicable to your business needs. So once again, on behalf of everyone at Husch Blackwell and on behalf of all of our presenters today, thank you so much for joining us. Don't forget to join our Wisconsin colleagues for their seminar next week. Don't forget to check out this or other presentations on demand on our website. And I look forward to seeing you all again, either virtually or maybe even in person in the spring. And my assistant, who has found her way to sitting up on my desk, do you have anything you'd like to share, Edith?
Yes, I would say thank you for all joining us, and don't forget to vote.
It's good advice for all of us. And this concludes our program. Thank you. Your hand is out of the screen. You got to wave. You got to put it over here. There you go.